It is a great privilege for us to be again joined in this panel, not only by renowned law of the sea experts, but also members or former members of international bodies that play a key role in the implementation of the convention. I believe we are also joined via Zoom by President Albert Hoffman, and we can check back on that later on in the discussion portion of the panel. Joining us now as moderator of this panel is Professor Patricia Galvao-Teles, who has been a member of the International Law Commission since 2017 and is an auxiliary professor of international law at the Autonomous University of Lisbon. Among many other distinctions, Professor Patricia has also been part of the Center for International Law for more than a year now as adjunct senior research fellow and co-director of the Singapore Academy of International Law. And we are very glad that with the relaxation of travel restrictions globally, she is able to join us today in person. Professor?
Thank you so much, Pia, and a very special thanks to Profco and to my very dear friend and colleague and partner in crime, Nilüfer Oral. After almost 2 years of intense virtual contact, where we've created the CIL E-Academy, which is really the reason why I'm connected to CIL now. It's really wonderful to finally be able to come in person and see very dear colleagues and friends in 3D and not just in the screen. We also have, of course, still a situation where we cannot all be together. And so this panel is partly in person and partly online. And for me, it's a great honor to moderate this panel today. It's always a difficult task when we're standing between the panel and dinner, which I hear will be wonderful. But it is a very important topic that we are addressing in this panel, because I think it's no exaggeration to say that the dispute settlement mechanism in Unclos, Part 15, is undoubtedly, I think we can say it's the most sophisticated dispute settlement procedure mechanisms in any international convention. And so it would be incomplete if we did not address and make an assessment of how the compulsory dispute settlement mechanism in Unclos has functioned so far. And for that purpose, we could not have a better lot of speakers, starting with Judge Wolfram, who's joining us online, and I hope we'll be seeing him on the screen very soon. And also Judge Koroma, Judge Treves, and Natalie Klein, and Alex Elfrink, who's also online. And when I say we could not have a better panel to discuss dispute settlement, I say it because we have people that actually have experienced the dispute settlement mechanisms in Unclos as former judges, both at the ICJ and at ITLOS. Judge Koroma also as a conciliator under Annex 5 conciliation mechanism, and Prof. Natalie Klein and Alex Elfrink as distinguished academics and practitioners who follow attentively this issue under the Unclos. So we will proceed with presentations one by one. I've threatened to ring the bell, the CIL famous bell. I think they took it away from me, but I'm sure somebody has it, and if necessary, because this is the largest panel in the conference. We have 5 speakers, and I know they have a lot of things to say, but if necessary, I know either Tara or Pia, our very competent MCs, will ring the bell if necessary, just to warn you to wrap up. So let us start first with Judge Wolfram, who I hope can turn on the camera. We don't see you, Judge Wolfram, yet. Okay, he's still on the phone.
I'm on the phone.
We can see you now and we can hear you.
Thank you very much.
Very nice to
Patricia?
see you. Very nice to
Yes,
see you.
I can see myself, but I can't see the others. But
Okay.
at least you can hear me, can't you?
Yes, and we have the pleasure to hear you speaking about if the dispute settlement procedure and the Unclos adequately designed to meet modern challenges. So you have the floor, Judge Wolfram.
Thank you very much, Patricia. Due to the topic of this conference, I would like to speak about what has been achieved in or by the Law of the Sea Convention. And I will try to develop what I'm going to say first and foremost upon the ruling principle, namely the common heritage principle. The common heritage principle is a very clear and very distinct outcome of the conference. Why is this so important? First, it overcomes the traditional way of doing international relations, namely coordination and cooperation, by adding a moral or ethical principle. Therefore, the common heritage and thus the convention transforms the international law into a new generation, a generation of international law not only governed by static principles like coordination and cooperation, but by a moral value. Perhaps this was not seen at the beginning as such, but it is very clear that this is now a dominant factor. This is, as I said, important, for it brings into international law an ethical value which didn't exist before, namely interstate solidarity. And it further brings into the law of the sea an institutional framework which implements this common heritage principle and thus, you may say, undertakes even two steps. First, by establishing a principle, and second, by implementing it. I'll come to the consequences in a moment. Tomiko has once qualified the Law of the Sea Convention as the Constitution of the Sea. If we understand the term constitution correctly, it is more than an organizational pattern, but it is always something particularly moral. Modern constitutions have an ethical background, and it is very often clearly expressed in the preamble of the said constitution. We do exactly the same here, namely, we do it in the preamble of the Law of the Sea Convention, but in particular in Part 11. Through this, the Law of the Sea Convention is shaking off, or it's supposed to shake off, state-centered nationalism. The common heritage principle now works on several levels. On the level between states, on the level between the law of the deep seabed system and states, individuals, and it also includes future generations. That is, we have now a guiding principle for now and for the future to come. So far, so good. It is positive in respect of the protection of the marine environment. The common heritage also plays, or at least should play, the solidarity in respect of fishery resources. This has been implemented by the implementation agreement. In respect of the protection of the environment, climate change, or working against sea level rise, this is equally governed by interstate solidarity, or should be. However, I would say, and there I see the challenges, We are elements of a new, single state-oriented nationalism. First, I would like to mention the war in Ukraine and as to remain on the sea, the impact on the use of the Black Sea and the Sea of Azov. But war is exactly the opposite of what the common heritage principle wanted to achieve. Therefore, this war in the Black Sea and in Ukraine, this form of aggression, totally unexpected, at least from my point of view, is contrary towards the new area of international law was meant to become, namely governed by ethical principles. The second challenge is the South China Sea. Here, one state wants to occupy and to monopolize a huge area of the sea, contrary to the law of the Sea Convention. And there is no indication of an openness for a compromise or for joint ventures. My third element, or my third challenge I would like to mention, is that there is not enough cooperation and to limit the CO2 emissions. Here, one state points to the other state, you go first, etc. What you can see from Australia still using coal or excavating coal is what I consider national egoism of a certain form. I finally, or semi-finally, would like to mention the biological resources beyond national jurisdiction. Instead of handing this over to the International Seabed Authority and allowing the International Seabed Authority to manage these resources, is for me an element of national egoism. Patricia, you will certainly protest, since you are involved, as far as I know, in the process of this new agreement. But it would have been much, much easier to declare the genetic resources beyond national jurisdiction as a common heritage of mankind. With a stroke of a pen, this could have been done, and leave it to the International Seabed Authority. My next and final point is, we have so far not been able, under the law of the Sea Convention, to provide for ports which allow the access of ships which have rescued migrants trying to leave their country via the sea. We all witness what is happening in the Mediterranean, but we should have thought about the boat people many years ago. This was the same problem and no solution yet been found. Let me come to my second point. Another achievement is the development of the dispute settlement system. The biggest achievement of the law of the Sea Convention is that it provides for a system of mandatory dispute settlement that goes beyond what has been done by the ICJ. However, if one looks upon this, how many cases go to Unclos? How many cases go instead to arbitration or to the ICJ? The ICJ in the moment has a full calendar, whereas others have in the moment less cases to deal with, many of them all of the sea cases. I'm not dissatisfied with the jurisprudence of the ICJ. In the contrary, the Black Sea case is a leading case for all of us, but there should have been a more equitable distribution of cases between Unclos, arbitration, and the ICJ. But even having said that, the system of adjudication faces certain challenges in themselves, namely there is a growing tendency not to participate in the proceedings. I refer to Russia, I refer to China in the most recent cases. This deprives the court or tribunal of its means to provide a judgment or award which is adequate for both sides. Secondly, I believe there is a more serious challenge to adjudication. Many cases touch upon community interests. The case, what is an island? Article 121, paragraph 3 is actually an issue which should be, at the end of the day, bind everybody who is party to the law of the Sea Convention. Instead, this was only issued in the context of two states parties, Philippines versus China. Therefore, it is recommendable that more traditionally oriented colleagues will protest. I believe ICJ or Unclos judgments should have a wider binding force than we traditionally anticipate. But to put it into one sentence, I believe that we should come to the understanding that if one of these courts takes a ruling, this ruling should be binding upon following courts unless the following courts have, due to factual reasons, feel that they can't follow this jurisprudence issued so far. This is rather a proposal which goes beyond what is traditionally believed, but we can have a discussion on that if you wish. These are my introductory remarks I wanted to make, and I believe that the Law of the Sea Convention is one of the most important new treaties in international law in the last 100 years, perhaps comparable to the Hague Peace Conferences, and it should be treated as a constitution, as Tommy Koch has declared, and we should live up to that. Thank you very much.
Thank you so much, Judge Wolfram. I see that the threat of ringing the CIL bell has
Tricia,
worked
could you speak a little bit louder?
Yes, I see that the threat of ringing the CIL bell has worked because you were very good with time, and I hope your fellow panelists will also follow suit so that we have more time for discussion, and especially you started by raising a number of important questions and, of course, making, as always, as we expect from you, very interesting and provocative proposals like having a binding force of international judgments for other courts in a way to better protect community interests. So we'll come back to that for our question time. So I give the floor now to Judge Koroma, former judge at the ICJ. Also,
I'm going to apologize very quickly. If we could ask the speakers to speak really close to the microphone.
yes. Okay. There's no button to turn on, no? They're automatically on. Okay. Okay, so I will speak closer to the microphone and give the floor now to Judge Koroma, former ICJ judge and also a member of the East Timor, the Timor-Leste Conciliation Commission, who will speak to us about the prospects for conciliation as a dispute settlement mechanism under Unclos. Judge Koroma, you have the floor.
Thank you. Professor Teles, we are fortunate to have.
Sorry, under the orders of Nilüfer.
Thank you to have you as chairing this session, coming from Portugal, a leading maritime nation historically. So I don't think a better choice could have been made. What I would like to render at this moment is to pay tribute to Professor Tommy Koch and Dr. Nilüfer for organizing such a comprehensive and coherent session to commemorate the 40th anniversary of the adoption of the Convention on the Law of the Sea. Oh,
That's the commemoration music.
I will not be exaggerating if if I say that for the patient's wisdom of Tommy Coe, the Unclos would not have been adopted in the form in which it was. You don't want to go into the history, I suppose. It's been written elsewhere. There were several attempts to adopt the convention, but at the last minute, the convention was scuttled, and it was not adopted, even at midnight. And you cannot imagine the amount of work he devoted to the adoption of the convention. As you would recall, the convention was negotiated at the height of the Cold War. You had the superpowers, you had the developed countries and developing countries, and you need someone with the skills of Tommy to have been able to navigate the negotiations towards the adoption of the convention. You could even recall some delegations would threaten not to participate in the negotiations if they were not allowed to leave the conference room to go and have a smoke. 40 years ago, don't forget, 40 years ago, it was common to smoke during the negotiation. And it's only with his patience wisdom he was able to cajole and coax this delegation to participate in the negotiation. So it required a lot of skills, a lot of Oriental wisdom, which he displayed throughout the conference, and that was what led to the adoption of Unclos. My task here this afternoon is to speak on the prospects for conciliation as a dispute settlement mechanism under Unclos. As usual, my friend and buddy, Professor Wolfram, George Wolfram, has said that, for example, the South China Sea dispute does not fall under the rubric of the common heritage of mankind, as one of the conciliators of the Timor Sea conciliation. I wonder if he had reflected, maybe I'm not saying that, and I will be coming to that later on, that all disputes will necessarily be solved or resolved through conciliation. But I'm just thinking that that dispute, that would not have been a prime candidate for conciliation, given all the interests involved and the geography and so on and so forth. As I said, this is just a response to the issue he raised in his presentation. So as I said, I'm asked to speak this afternoon on what role could conciliation play as a dispute settlement mechanism under Unclos. Some years ago, a distinguished scholar and observer of Unclos, I'm not going to name him here, you all know him, a distinguished scholar and observer of Unclos declared that the dispute settlement provisions of Unclos had not played the effective role that was anticipated at the adoption of the convention. In that article which the author wrote, he singled out conciliation as being totally absent in the settlement of disputes under the Law of the Sea Convention. But what he could not have anticipated was that the wind was blowing in his direction. Not long after that article had been written, in April 2016, Timor-Leste initiated compulsory non-binding conciliation proceedings against Australia under Annex 5 of Unclos, regarding its maritime dispute. It was the first of its kind under the convention. Compulsory conciliation under Part 15 of Unclos can be invoked unilaterally by one state against another. It is regarded as a fallback position for certain disputes that have been excluded from the compulsory dispute settlement mechanisms. Article 298.1 establishes two conditions for the invocation of the of that method of dispute settlement mechanism, namely that the dispute should have arisen subsequent to the entry into force of Unclos, and secondly, there should have been no agreement, or there should have been extensive negotiation between the parties, but there had been no agreement. Although the conciliation, I would call it the Timor Sea conciliation, was first of its kind, the conciliation was constituted in less than 3 months. It dealt with a challenge to its competence. And less than 2 years later, on the 6th of March 2018, the parties signed a settlement treaty on the basis of the proposal of the Commission. Oh God, 2 months. 2 months. As I was saying, that the party was able to sign an agreement on the basis. 2 months later, the Commission issued its report, bringing to a conclusion the first ever conciliation proceedings under Annex 5 of Unclos. Thus, the successful outcome of that process is a demonstration of the vivid and effective role conciliation played and could play as a dispute settlement mechanism under Unclos. I'm asked to divine, to foretell the prospects, the likelihood, the possibility of conciliation as a dispute settlement mechanism under Unclos. I would say, based on the evidence, that the prospects are encouraging, but provided all the stars are aligned as they did with respect to the Timor Sea conciliation. Conciliation as a method for settlement of international disputes is a mechanism which will proceed to the impartial examination of the dispute and attempt to define the terms of a settlement susceptible of being accepted by the parties or affording the parties with a view to the settlement. This was a definition of conciliation written over 50 or more years ago. Thus, though as a dispute settlement mechanism, conciliation is not new. It is part of the Unclos architecture, but in Unclos, it assumed distinctive features. The main purpose of conciliation under Part 15 is to facilitate the parties to reach an amicable settlement of their dispute, not for the Commission itself to solve it for them. The Commission can hear the parties, examine their claims and objections, and make proposals to the parties with a view to reaching an amicable settlement. According to Article 298 of Annex 5, It stipulates that the function of the Commission should go beyond purely legal considerations and focus on non-legal measures, including to the extent necessary for an amicable settlement to be reached. In the case of the Timor Sea conciliation, it became evident when it became evident to Timor-Leste, following Australia's declaration under Article 298 on the 11th of March 2002, that Australia had exempted its maritime delimitation dispute from the jurisdiction of the ICJ and Unclos and possibly arbitration. Timor-Leste therefore decided to invoke the compulsory conciliation provision under Unclos in accordance with Article 298. I said earlier that while conciliation as a dispute settlement mechanism is not new, but that under Unclos it assumed some distinctive features. These features included the constitution of the Commission itself. For the Commission to conduct its proceedings effectively and successfully, it should enjoy the confidence of the parties, who should regard it as impartial. In the case of the Timor Sea conciliation, a mixture of diplomatic and legal skills were deployed to enable the Commission to come up with a proposal acceptable by the parties. Although the members of the Commission were appointed by the parties respectively, but right from the word go, right from the commencement of the proceedings, the Commission worked as a team. In my view, any future Commission to be successful would have to be served with similar qualities for it to be potentially successful. Also, worth mentioning is the cooperation of the parties that the Commission enjoyed throughout the proceedings. During most of those proceedings, both parties cooperated with the Commission, while at the same time they stated and defended their legal and other claims as was to be expected, given the national interests that were involved. Moreover, for a conciliation commission to be successful under Unclos, it must demonstrate the necessary flexibility and creativity regarding its rules of procedure. Whereas in judicial and arbitral settings, the rules of court or the tribunal have to be maintained and strictly observed. In a conciliation commission aiming for an amicable settlement, flexibility would have to be maintained with, of course, the consent of the parties, for the Commission to be actively engaged with the parties throughout the process. It is also worth repeating that the basic function of a conciliation commission is to facilitate for the parties to reach an amicable settlement of their dispute, and not for the dispute to be settled by the Commission, by the Conciliation Commission itself. And I don't want to leave you with the impression that the Commission will not have to apply the law. Both parties in the Conciliation Commission, as you are aware, did operate or invoke Unclos to buttress their claims. They brought under in terms of the delimitation of the continental shelf, both the median line argument and that of distance or prolongation were advanced, but it was up to the Commission, in our view, in view of the Commission as a whole, not to adopt one submission as correct or not, but to see how best to fuse those two submissions in the interest of an amicable settlement. Following its decision on competence to conciliate the dispute, the Commission embarked on hearing the parties, listened to their claims and objections, and where required, or when required, as I said, was able to fuse the arguments of the party to come up with an acceptable position. This does not happen either in terms of the judicial settlement or in terms of arbitration, because the judicial settlement is governed by the law. The law is the governing principle there, both in terms of the statute of the court or in terms of the statute of an arbitration. But in terms of conciliation, a commission does have a leeway to try to reach an amicable settlement. Under Unclos, the Commission is required to produce a non-binding report regarding any agreements reached, and if no agreement is reached, to state its conclusions and recommendations on questions of facts and laws relevant to the dispute. Both parties are then under obligations to negotiate an agreement based on conclusions and recommendations of the Commission. If the negotiation fails, the parties have an obligation to submit the dispute by mutual consent to binding adjudication or arbitration. I know I have limited time. The outcome of the Commission has been lauded as a success. Several factors contributed to what has been qualified as a success. Compulsory conciliation under Unclos involves fact-finding, mediation, and negotiation, and even some amount of adjudication and arbitration. The compulsory nature of the proceedings was largely responsible for compelling Australia to engage in the process after its objections to the competence of the Commission. Australia particularly participated fully in the proceedings and in good faith. And again, both parties performed admirably when it came to cooperating with the Commission. And as I said, the Commission is not bound to apply the law strictly. The Commission, or a conciliation commission, is allowed by virtue or under Unclos to take into consideration political and economic concerns of the parties with the objective of proposing a recommendation. After all, we're not imposing, it's proposing a recommendation that might be acceptable to both parties. As stated earlier, effective conciliation requires a careful mix of diplomatic and legal skills and their deployment at different stages of the process. The one-year limit and the requirements on the consent and the content of the report were helpful in creating pressure on both parties and the Commission to come up with a workable proposal. So, in spite of the above, I'm not going to say, I'm not suggesting that compulsory conciliation is superior to adjudication or arbitration as a method of dispute settlement. but I hope have reflected why conciliations under Unclos could lead to the peaceful settlement of a dispute similar to the Timor-Leste Australia dispute on the Timor Sea. But please remember, every dispute is unique, both in terms of its geographical features and historical and other circumstances. So we should not be lazy to say that now all disputes would necessarily be resolved through compulsory conciliation, but the mechanism is available, and if you deploy the right mix, the right skills, I think it could lead to an effective settlement of a dispute under Unclos. Thank you very much, and thanks for accommodating me.
Thank you so much, Judge Korom. This is really an interesting experience. First one, unique one, successful one. But I think, as you say, you need to have the right circumstances for resorting to conciliation. But I'm sure there'll be questions about that. So I give the floor now to Judge Travers, former Unclos judge, who will speak to us about if the different forums have led to fragmentation or harmonization. Judge Travers, you have the floor.
Thank you very much, Patricia. First of all, I wish to thank the Singapore authorities, Tommy, Ko, Nilufer, and all their team for inviting me in this moment that cannot but recall to me that particular night at the end of April of 40 years ago, when the convention was put to a vote under the chairmanship of Tommy. I was in the room, and the emotion is still there, 40 years past. And I want also to thank the organizers for having proposed to me a title that looks a bit strange, but is very stimulating. Everybody knows that once the negotiating parties at Unclos agreed, and it was not easy, that compulsory adjudication would be useful for the convention to be, they could not agree on which adjudicating body would exercise this compulsory jurisdiction for adjudicating disputes under the convention. And the end result was the so-called Montreux formula, which is more or less reproduced in current Article 287 of the convention, on the basis of which more than one forum was a possible adjudicator, not only the already existing but widely criticized at the time International Court of Justice, but also a new body to be created for the Law of the Sea, the Law of the Sea Tribunal, and arbitration that had always existed and had its partisans. You know the mechanism of the Montreux formula. I won't go into detail, it would take too much time. It requires that the two parties have made a choice for one of these forums. And if they don't make the same choice, arbitration would be the presumed, the deemed forum. And so if they don't make the choice, also they are deemed to have chosen arbitration. So we have a system in which not one forum, but in fact more than one, the International Court of Justice, the Law of the Sea Tribunal are the two permanent bodies, which are a possibility. Then we have arbitration of a general competence. We have also specialized arbitration, but this seems to be, let's say, a less fortunate partner, and so we will leave it aside. May I only recall that in the recent arbitration between Ukraine and Russia on coastal state rights in the Black Sea, one party, I think Russia, argued on the basis of clauses favoring Annex 8 arbitration, but it was not successful for reasons indeed that it is difficult to divide complex disputes into so many smaller disputes that belong to the competence of the specialized arbitrators. So when we discuss about harmonization or conflict in a plurality of fora, we are talking about the jurisprudence of the International Tribunal for the Law of the Sea, of the Annex 7 arbitration tribunals, and also of the International Court of Justice. Why did I put International Court of Justice last? Should be the first. Well, because in no case has a dispute been brought to the International Court of Justice on the basis of the jurisdictional provisions of Unclos. The International Court of Justice is very important for the law of the sea because it has applied and continues to apply the Unclos, the United Nations Convention on the Law of the Sea, but not on the basis of the convention, but on the basis of its own statute or other treaties. But in any case, it is important to consider the jurisprudence of the ICJ, of Unclos, and of Annex 7 tribunals. May I just add one further point before going into the heart of the matter? The question put to me, fragmentation, harmonization, was not an item in the preparatory work. States were keen to ensuring that there would be a judge with compulsory jurisdiction. They didn't care very much about questions about fragmentation, proliferation, that were to become so fashionable in the decades after the convention was adopted. There was even an eminent delegate, the delegate of Thailand, Professor Sukarit-Kul, that argued that, and I'm quoting him, concurrence of jurisdictions rather than conflict would operate to improve the quality of adjudication. Of course, we can agree or disagree, but this is the little we can find in the preparatory work. They were not concerned about fragmentation. And then another preliminary issue that goes towards the idea that it is more likely that there is harmony than fragmentation. The jurisprudence on the interpretation of the Law of the Sea Convention, from whatever source it comes, ICJ, Unclos, arbitration, comes from a community of lawyers that are more or less all the same. Most of the judges, arbitrators, and counsel involved in cases under Unclos belong to the same community. Sometimes the same persons exercise different roles in law of the sea disputes or are involved in different adjudicating bodies. For example, it has happened in several cases that judges of the Unclos serve as ad hoc judges of the ICJ. This was in particular the case of Judge Mensah, Judge Kateka, Judge Kot, and that once, and this is even more remarkable, the president of the International Court of Justice, Judge Abraham, served as judge ad hoc in a case before a chamber of the Unclos. Several Unclos judges or former Unclos judges have served and are serving as arbitrators in Annex 7 arbitral tribunals, in some cases as president, as in the case of Judges Mensah, Nelson, Peck. Counsel frequently appearing before the ICJ also appear before the Unclos and Annex 7 arbitral tribunals. This, in my view at least, ensures that most of the members of adjudicating bodies and the lawyers appearing before them are fully aware of how other adjudicating bodies competent under the Convention have interpreted it. This facilitates the harmony of the jurisprudence of the adjudicating bodies that may be called upon to interpret the Convention. I would like to quote an early speech by the late president of Unclos, Judge Chandrasekhara Rao, when he spoke on the occasion of the opening of the Unclos headquarters in the year 2000, he stated, and I quote, "It is to be hoped that each international tribunal or court, though autonomous in itself, will not ignore precedents of other bodies, thus ensuring the harmonious development of the law of the sea. It is of the interest of sound jurisprudence that a judicatory body show mutual respect to each other's decisions." This statement seems to me an accurate formulation of what was and still is, I think, the policy of Unclos. I had the opportunity, and may you permit this small self-quote, to make a point in a similar vein in my declaration in the Bay of Bengal case. While underscoring that each tribunal may have a different outlook and contribute constructively to the development of the law, I had the opportunity of stating, and I quote myself, "All courts and tribunals called to decide on the interpretation and application of the Convention should, in my view, consider themselves as part of a collective interpretive endeavor, in which, while keeping in mind the need to ensure consistency and coherence, each contributes its grain of wisdom and its particular outlook." It is, in light of these statements, it is no wonder that the jurisprudence of the Unclos, on the Unclos presents only a limited amount of conflicting statements. This may also be due to the fact that judgments of different courts and tribunals dealing with the same questions of interpretation of a provision of the Convention are quite rare. Keeping in mind this, it is nonetheless possible to indicate some notable trends and examples. I will now embark in a perhaps not complete review of the jurisprudence in search of signs of harmony or conflict. First of all, we can note, since the first judgment on the merits of the tribunal, the Saiga case, that there is a clear trend in the Unclos jurisprudence to follow that of the International Court in matters of general international law, such as state responsibility. For instance, in the Saiga case, Unclos relied on the permanent court in the Chorsau case to define the notion and scope of reparation in case of an internationally wrongful act, and on the judgment of the same court in the Polish interest in Upper Silesia to define the legal nature of domestic law in the perspective of international courts. More recently, and we are jumping to much more recent times, the tribunal followed the court in a permutation of its jurisprudence, which entailed that also the tribunal changed accordingly its position. This happened as regards the requirement of plausibility that the court introduced in 2009 as a necessary prerequisite for provisional measures in the Belgium versus Senegal case, and resorted to also in subsequent provisional measures order, including a few weeks ago in the provisional measures order in the Ukraine versus Russia case. As in the international provisional measures order before Belgium versus Senegal, this requirement was not mentioned in the early provisional measures decisions of the tribunal. Nonetheless, the tribunal relied on this requirement in its order of 2015 on provisional measures in Ghana versus Côte d'Ivoire and in all other more recent provisional measures order. It is likely that the presence as ad hoc judge in the Unclos chamber dealing with the Ghana-Côte d'Ivoire, which introduced the plausibility in the Unclos jurisprudence of the then president of the International Court, Judge Abraham, contributed to the acceptance of this requirement, as Judge Abraham had been in the International Court of Justice the main proponent and supporter of plausibility. There are also cases in which the court follows the tribunal. This happened in cases in which the provisions of Unclos concerning the settlement of disputes or the rules of the tribunals were adopted with the purpose to produce an improvement to the corresponding and criticized provisions of the statute and rule of the ICJ. In these cases, we can see a constructive dialogue between the two permanent bodies. One notable such case concerns the binding character of provisional measures. You know that the Law of the Sea Convention is unequivocal about such binding character, but that this was a very debated issue in the jurisprudence of the International Court of Justice. With the Lagrand case in 2000, the International Court of Justice followed not yet the Unclos, but the Unclos in accepting the idea that the provisional measures it indicated under Article 41 of the statute were binding. And this has been kept in further jurisprudence of the ICJ as of the Unclos. Similar dialogues, I won't go into detail, can be remarked about the time limit of the submission of preliminary objections, where criticized provisions of the rules of the court were corrected in the rule of the Unclos, but then the court thought that the correction went too far and made a half step backward. This is constructive dialogue between courts. And the same can be said about the practice of notes by judges in the deliberation of judgment that were a strict prerequisite in the practice of the ICJ, but criticized as too time-consuming by many observers. The Law of the Sea Tribunal decided to do without notes, and the ICJ followed it at least halfway, eliminating notes in cases different from the main cases on the merits. Another aspect that, of course, is worth seeing is interpretation of substantive provisions of Unclos. And perhaps we can consider briefly delimitation of maritime areas, because this was the subject in which the court had built an important jurisprudence, and many observers, including former presidents of the ICJ, were concerned that the tribunal, if it had a chance to touch on this subject, would subvert solid jurisprudence. Well, this did not happen. Bangladesh, Myanmar, the first case of the Unclos dealing with delimitation, indicates clearly a will of the Law of the Sea Tribunal to be part of a consistent jurisprudence. Among the many quotes I could do, but perhaps we can read these 3 lines. In applying, the tribunal said in that case, in applying this method, the 3-stage method developed by the court, to drawing of the delimitation line in the present case, the tribunal, taking into account the jurisprudence of international courts and tribunals on this matter, will follow the 3-stage approach as developed by the most recent case law on the subject. The tribunal confirmed this approach in Ghana, Cote d'Ivoire, and the International Court of Justice continued to confirm this orientation, even in its most recent judgments, Somalia versus Kenya, in which, it is interesting for our purpose, it quoted in support not only its own jurisprudence, but also that of Unclos and of the Bangladesh versus India Arbitration Tribunal. Now, the interesting point, perhaps even though it nuances the harmony, is on matters of delimitation, can be found in the fact that the Unclos Special Chamber in Ghana, Cote d'Ivoire, accepted the indication of the arbitral award in Bangladesh versus India that, and I quote, transparency and predictability of the delimitation process as a whole are also objectives to be taken into account in this process. I recognize the pen of my beloved colleague Rudiger Wolfram, but this is a parenthesis. It must be noted, however, that in Somalia, Kenya, the ICJ did not refer to transparency and predictability, so half a dialogue. Perhaps the only case in which a contrast of positions in the jurisprudence of adjudicating bodies called to interpret Unclos is unequivocal, concerns the interpretation of Article 281, paragraph 1. In performing these tasks, two different Annex 7 tribunals have held opposing views. Article 281, paragraph 1 provides that when a procedure has been agreed upon by the parties to the dispute, the procedures provided for in Part 15 of Unclos apply only if such a procedure has been unsuccessful and, I quote, the agreement between the parties does not exclude any further procedure. The Annex 7 Arbitral Tribunal in the Southern Bluefin Tuna, New Zealand versus Japan, Australia versus Japan, interpreted the exclusion referred to in Article 281, paragraph 1, as not requiring an express manifestation. The Annex 7 Award on Jurisdiction and Admissibility in the South China Sea explicitly rejects this view and states that the better view is that Article 281 requires some clear statement of exclusion of further procedures. This contrast may be explained by the strong arguments set out in the separate opinion of arbitrator Sir Kenneth Keith and the views expressed in scholarly comments in the award. It seems interesting to conclude this review of cases in search of signs of harmony or of conflict, mentioning a view held by two Annex 7 awards that the special chamber of Unclos, while not rejecting it, found a way to distinguish, reaching a result opposite to that reached by the two awards. The Annex 7 award in Chagos Archipelago case held that it lacked jurisdiction on the establishment of a marine protection area because the determination of who was the coastal state entitled to such establishment depended on the issue of sovereignty on the Chagos Archipelago. And this was an issue on which there was no jurisdiction under Unclos. Similarly, the other Annex 7 award in Ukraine versus Russia case concerning coastal state rights, the arbitral tribunal held that it had no jurisdiction over all of Ukraine's claims alleging Russia's violation of Unclos that were premised on the determination of sovereignty over Crimea. The tribunal stated that it had no jurisdiction on these disputes because they did not concern the interpretation and application of Unclos. It did not accept the arguments of Ukraine claiming that the issue of sovereignty over Crimea was settled in light inter alia of a General Assembly resolution. Well, in the 2021 judgment on preliminary objections in the Mauritius versus Maldives delimitation case, the Unclos Special Chamber, while not rejecting the reasoning of the two arbitration tribunals, distinguished the coastal state rights case and affirmed that Mauritius was the coastal state of the Chagos Archipelago because there was an advisory opinion of the ICJ that affirmed so, while in Ukraine versus Russia, and I quote, the arbitral award did not have the benefit of prior authoritative determination of the main issues relating to sovereignty claims to Crimea. While the Chamber's argument seems debatable in view of the non-binding character of the ICJ's advisory opinions, for our purposes, it seems interesting to note that the Unclos Special Chamber took its decision without rejecting the main reasoning set out in the two arbitral awards, relying on the distinction in the factual situation, namely in that in the case before it, a judicial body, even though in the exercise of consultative jurisdiction, has taken a decision on the sovereignty issue. I come to my conclusion, which will be extremely brief. The picture just broached is one of uniformity and lack of contrast between the attitude on procedural and substantive matters of different courts and tribunals called upon to apply and interpret Unclos. This is confirmed by the fact that there is only one clear example of diverging attitudes and that it does not involve permanent adjudicating bodies. Thank you for your patience.
Thank you so much, Judge Travis. I think you've done an excellent job to demonstrate how the debates about 15 years ago about the proliferation and fragmentation of international law and international tribunals have not yet, or have not indeed come to be real fruition because of the maturity, I think, of the courts, the constructive dialogue that you mentioned, but also, I think, a significant commonality in the community of lawyers and judges before those courts. So I give the floor now to Professor Natalie Klein from University of New South Wales, who will speak to us about compliance with the decisions of Unclos courts or tribunals and assessment. Natalie, you have the floor.
Right. Thank you very much. And I would like to join with the other speakers in extending my thanks to the organisers for the opportunity to be able to speak. Indeed, I'm very grateful to be on a panel with such distinguished speakers, and also grateful to have been given the opportunity to speak on such an interesting topic in terms of compliance with the decisions of Unclos courts or tribunals. What I'm going to be presenting is our initial findings, and we are preparing a bigger paper. I'm working on this with a recent UNSW graduate, Jack McNally. So we do have some preliminary views which I can share with you today. So when we're looking at the universe of cases that have been decided under Unclos, at the end of the day, we're only looking at about 45 decisions that have been rendered. In the same time period that ITLOS has been in existence, the WTO dispute settlement panels have issued close to 600 awards. So it's a fairly small caseload that we're looking at. And then given that we do have the Montreux formula with the possibility of 4 different choices, what we also see with Unclos dispute settlement is that all the decisions have been made either by ITLOS or by Annex 7 arbitrations, while the ICJ has been making decisions about law of the sea. It has not been doing so under the auspices of Part 15 of Unclos. So we can look at the majority of cases that have been decided under ITLOS. The 29 cases, as we heard from Judge Jesus earlier, can be divided between the prompt release procedures, provisional measures decisions, some decisions on contentious cases, as well as 2 advisory opinions. There have also been 16 cases that have been turned to Annex 7 arbitral tribunals, and 2 of those judgments are currently pending. And of course, as we've heard from Judge Karoma, we've also had 1 compulsory conciliation. Now, in terms of thinking about compliance, the first thing that we really needed to try and work through is what do we mean by compliance? So as a general matter, compliance is concerned with matching behaviour to a particular rule. So that's our starting point. But you'll see some commentators say, well, we need to actually look for some causative element. And certainly looking at Yuval Shani's work on judgment compliance, he has defined judgment compliance as a causal relationship between the contents of judicial decisions and state practice, leading to a convergence of the 2. So we're looking at the fact that a judgment has been issued, and then because of that judgment, a state has taken particular steps. And also we have to acknowledge, on the one hand, we have compliance, and then at the other end of the spectrum, we have defiance in the face of a judgment, whereby a judgment is firmly rejected, possibly denounced as invalid, and there's an explicit refusal to comply. And of course, since we're talking about a spectrum, somewhere in between, we will have part compliance, where some aspects of the judgment will be followed, but not all. Or we might have at least sort of partial compliance, where there's a bona fide effort to comply, even if those efforts don't yield the precise results we might have expected. So then if we go through the different 29 cases that have been decided by ITLOS so far, I thought first of all we could focus on the prompt release cases. So once we're looking at the prompt release decisions, the 9 of them, as we've heard, most of these were from the early decisions of the tribunal. Among those cases, we know the Chaziri Rifa was settled before it reached a final decision. 2 of the cases were dismissed on jurisdiction and admissibility grounds, which then left us with 4 cases, possibly 5, where we do have a situation where the tribunal issued a decision saying how much bond should be paid, the amount was paid, and the vessel was released. I wasn't able to find precise information about the Monteconferco actually paying the bond and being released, but it seems the Monteconferco is still in operation, so seemingly it was. I thought at first that the Volga case might have been the one case of non-compliance here, because under Australian legislation, the Volga vessel was scrapped. But it seems, in fact, that the owners of the Volga challenged the decision before the Australian courts and ultimately opted not to pay any bond. So as a result of that, maybe Australia would have complied if they'd paid the bond, maybe they wouldn't have, we don't know, but the bond was not paid, so the vessel was scrapped under the Australian legislation. Now, if we look to the remaining ITLOS cases, out of the 29 cases, 18 were either prompt release proceedings or provisional measures decisions. And for the sake of time, I'm putting the provisional measures decisions to one side. So when we start looking at those decisions, we see that 2 of them were settled before a decision on the merits. Again, we had cases that were dismissed for jurisdiction, the Louisa. There is 1 case that's currently pending. We also have 2 advisory opinions, which effectively leaves us just with 5 decisions on the merits to have a look at in terms of compliance. And then within those 5 cases, 2 of them are maritime boundary disputes. And my initial view on this is that you do tend to have compliance with maritime boundary decisions because of the need for stability in maritime boundaries, third state interests in having that kind of certainty, but that is a situation we need to explore a bit more deeply in the paper to see if that initial impression is true or not. So that leaves us with 3 cases that have been decided by ITLOS to try and determine levels of compliance. In relation to the Sega, there were delays in Guinea's responses, but the vessel was released and the compensation was gradually paid, albeit in instalments. For the Virginia G, ITLOS awarded compensation to Panama, and Guinea-Bissau reported to the tribunal that it was making all necessary diligences to comply with the decision. We still need to pin down whether that money was paid or not, but it sounds like they were trying to. In any event, it seems the Virginia G was still sailing until it broke down and ran aground in Senegal and became a complete loss in 2015 due to looting. Then, in terms of the North Star, the tribunal determined that there had been a breach of Article 87 of the Convention. Compensation was awarded, and Panama subsequently communicated with the agent of Italy requesting information about compliance, and I've only been able to find informally that Italy did in fact pay the compensation, albeit with some delay because of some unhappiness about the final outcome of the decision. But seemingly all vessels released and seemingly perhaps all compensation paid. So then, if we turn to the Annex 7 arbitrations and go through the 16 cases that we have here, so once we start looking through the different arbitrations, we can see that there were at least 4 cases that were discontinued or settled, and that there were 2 decisions where there was a lack of jurisdiction, and as I mentioned, 2 of those cases are still currently pending. So then if we boil down to our 8 cases that are remaining, again, we've got 3 of them in which are maritime boundary cases where hopefully compliance has been a bit more forthcoming. And so we'll focus on the remaining 5 arbitration decisions. And of those 5 decisions, 3 of them are related to the seizure of vessels and crew. So in terms of what happened in those particular cases, well, the Arctic Sunrise is an interesting one in that Unclos provisional measures were issued requesting or ordering that the crew be released and that the vessel be released. And that did happen, but it's unclear that necessarily the order caused the release of the vessel and the crew. There was perhaps other motivations in terms of the Winter Olympics coming up and pressure on Russia in that regard. When we got to the merit stage of the arbitration, Russia was ordered to pay compensation, and in 2019, Russia and the Netherlands did reach an agreement, but it was a without prejudice agreement. And again, some question must be asked about whether the judgment really caused this payment to occur. For the Dusgit integrity, during the course of those proceedings, the master and vessel were released. There was a settlement agreement that was reached. The case, though, proceeded to a reparations phase, and at that point, Sao Tome chose not to participate. There's a large award of reparations made against Sao Tome, which I do not believe has been paid as yet. If anyone is listening and knows the information that I don't have yet, please feel free to email me. Then finally, with the Enrique Lexi, as we know, the Annex 7 Tribunal decided that the Marines were immune from prosecution in India and that Italy had breached Articles 87 and 90 of the Convention because of the interference with the Indian fishing vessel and the death of the 2 fishermen. And the tribunal found that India is entitled to a payment of compensation in connection with the loss of life, physical harm, material damage to property, and moral harm suffered by the captain and other crew members. So the tribunal didn't reach a definite amount of compensation, but left it to the parties to determine. So the parties did negotiate and extended the potential jurisdiction of the tribunal while they continued those discussions. And ultimately, in June 2021, India's courts closed the cases after Italy paid compensation of 100 million rupees. India subsequently agreed with Italy's request that the arbitral proceedings be closed, following Italy's assurances in relation to the prosecution of the Marines in Italy. So those proceedings were closed. However, the Italian authorities then, several months later, dropped their investigations into the Marines on the basis of a lack of evidence. Turning to the Chagos Marine Protected Area arbitration, in the end, really, if you look at the decisions that were made, there were quite a few decisions that were not made in that tribunal. Obviously, we just heard a decision about the tribunal not having jurisdiction to decide on whether there was a coastal state or not. And also, the tribunal did not decide whether the MPA in itself was unlawful or not. But what the tribunal did find was that the declaration of the MPA was a violation of requirements relating to due regard and good faith that the United Kingdom owed to Mauritius. So as a result, the United Kingdom did engage in further bilateral consultations with Mauritius, that's up on its website, about establishing the MPA. But as we know, there have been subsequent events to that decision in any event. So on the whole, the compliance record is looking relatively good. It does seem to be making an impact. And then, of course, we get to the South China Sea arbitration. And I get to that with about 2 minutes remaining, so I'm sure I'll cover everything to do with that case in that time. And you get the sense from the dispositif, if you weren't already aware, of the wide range of issues that were covered in that arbitral proceeding. And as I'm sure you all know, China did not participate in the arbitration, and it did completely reject the award. So I thought just for the purposes of today's discussions, I would just focus on a couple of elements from that particular award in terms of trying to assess compliance. And there's certainly information available on the web trying to track China's compliance. One change that commentators have noticed is that China doesn't rely quite as strongly on the 9-dash line, perhaps as it did prior to the arbitration. It hasn't abandoned that claim, but now tends to refer to the 4-Sha approach, which involves drawing baselines around the claimed island groups. And of course, the tribunal did say in the course of its judgment that putting those kind of baselines was not permissible under the convention, that observation was not included in the actual dispositif of the award. It's also been noted that given that the tribunal made findings that all these small features were either rocks or they were low tide elevations, it's been noted that China has not tried to explicitly claim continental shelves or exclusive economic zones off these specific features. However, China does still continue to occupy Mischief Reef and Second Thomas Shoal, despite both features being considered low tide elevations and particularly falling within the EEZ and the continental shelf area of the Philippines. So clear non-compliance there. And just briefly to mention in relation to fishing, there was some potentially initial compliance in relation to traditional fishing rights when an agreement was reached between the presidents of China and the Philippines in relation to Scarborough Shoal. But since then, more recently, Philippine fishers are being excluded from the area. China has maintained a fishing moratorium during the summer months. Philippines has told its fishers it should ignore that moratorium because of the award and continue to fish in the area. And China has maintained an aggressive approach to law enforcement, including prevention of Philippines fishing in its own EEZ, despite what was decided in the arbitral award. So that case probably stands as one where it's a little bit of a stretch to find any sort of compliance as we would typically understand it. Given the time, I'll just skip to my final reflections on this particular issue. So in the end, when we're only looking at sort of less than 50 judgments and when they all get boiled down, we're sort of looking more specifically at about 13 cases to try and assess compliance. And I have to admit, I was actually pleasantly surprised to see the amount of compliance that had followed the decisions. So of course, the next question is, well, why? Why were we getting the compliance with the decisions as I've outlined? Because we know, and we've already heard from Judge Koroma, that each individual case carries its own history and its own dynamics that would undoubtedly influence the resolution of the dispute and also the responses to the judgment. So what has generally compelled states then to comply? I mean, obviously it could be the economic importance of the shipping and the fishing industries that have been involved in some of these cases. Also, of course, the oil industries for maritime boundary disputes. Perhaps also relevant is that states would not resort to the resolution of their law of the sea disputes before these courts or tribunals unless they saw that there was real help to be achieved for the resolution of their disputes. In reflecting on ICJ practice, Jones has observed that judgments that entail compromise or allow for cooperative efforts are generally implemented with ease, and I suspect that is probably true of the Unclos cases as well. I think we also have to make an assessment that goes beyond compliance. It's not just about whether a state has followed a judgment or not, but also the outcomes of the decisions. What other outcomes have happened? And we've already talked a little bit about the interpretation of Article 121.3. Have other states followed that? Or if we look at the cases specifically, did Guinea change its customs law after the tribunal said that it couldn't apply that within its EEZ? So we can also think about outcomes in terms of the influence of the judgments on subsequent decisions. And also I think when we start contemplating outcomes, we can consider the cases that were settled. And then the very existence of the legal proceedings seems to have been relevant. So I think the assessment really brings us back to our much bigger questions about the role and the aims of dispute settlement under Unclos. And the key aspects, I would think, are all about ensuring the peaceful settlement of disputes, upholding the rule of law, and trying to ensure good governance or the good public order of the oceans. And these are three themes that Kate Parlett and I have explored in our new book. But I think when we reach these types of overarching aims, then it's much more likely that compliance will follow. So thank you for your attention and the opportunity to present.
Thank you so much, Professor Natalie Klein. I think we're all going to want to read your forthcoming book together with Kate Parlett. It's true that I think sometimes we have a tendency to assess the positive outcome just when we look at the decision and not what happens afterwards. So I think this is a very interesting aspect, dimension that sometimes is not looked at, but it's the only way we can have the full assessment of the impact of the dispute settlement mechanisms under Unclos. So now we have a final speaker. I know, although I threaten I've not been very good with timekeeping, but the presentations were also good, and I think we'll have to shorten a bit the time for discussion and delay a little bit dinner. But with that, I will give now the floor to Professor Alex Elferling, who's joining us from the Netherlands, I think. He's with the Netherlands Institute for the Law of the Sea, and he's going to speak to us about 25 years of uncaused dispute settlement, a general assessment. I don't see you on the screen, Professor Elferink. I see you now. So welcome, and you have the floor.
Yeah, thank you, Professor Perez. Thank you, Patricia. And thanks to the organizers for inviting me to this conference. I'll just... it's a pleasure to be on a panel with such distinguished colleagues, and I welcome this opportunity to reflect on the role of dispute settlement under the Convention. Quite a challenge at the same time, in particular after 4 eminent speakers and before dinner. I'd like to start by referring you to an observation of Ambassador Kiko, the president of the first conference that adopted the convention. This concerned a statement at the final session of the conference in December of 1982. He had this to say about dispute settlement. About the dispute settlement provisions of the convention, and I quote, "The world community is interested
sorry,
in the
Alex.
settlement of disputes and
I'm so sorry.
the settlement of disputes between states have
Hi.
been advanced."
Do you think, I'm so sorry, do you think you can speak on the speakers? Because we actually are having trouble, hearing you without the speakers. Apologies for interrupting.
Yeah, sure, that's fine. Is this better or?
Yes, much better. Much better.
Okay, well, good to hear that. So I'll start again from the quote of Tomiko, as I said, President of the Third Unclos. And this is what he said about the dispute settlement provisions of the convention. The world community, and I quote, "The world community's interest in the peaceful settlement of disputes and the prevention of use of force and the settlement of disputes between states have been advanced by the mandatory system of dispute settlement in the convention." End of quote. As Ambassador Coe's observations indicate, the main achievement of the convention is that its part 15 makes dispute settlement compulsory when certain conditions are met. Due to the limited time, I will not address the latter point, but will focus on compulsory dispute settlement as such. With the convention in force for a couple of decades, and by now a quite abundant case law spanning 25 years, there would seem to be sufficient materials to assess whether Part 15 has delivered. No doubt the case law has contributed to the clarification of the law. This is significant and also unavoidable because many provisions of the convention contain vaguely worded or generally framed provisions. Such compromises were necessary to reach agreement on the convention's language, but may subsequently lead to disputes over their scope and meaning. Let me just give a couple of examples. Many more could be given. Courts and tribunals have successfully developed the content of Articles 74 and 83 on the delimitation of the exclusive economic zone and the continental shelf, which are devoid of substantive content. Although this development raised the question whether it reflects the interest of all states that negotiated these compromise texts, the judiciary's approach seemingly has been generally accepted. In Chagos, the arbitral tribunal, among others, provided an elaboration of the due regard requirement contained in Article 56 of the Convention. Article 56 provides that, and I quote, in exercising its rights and performing its duties under the Convention in the exclusive economic zone, the coastal state shall have due regard to the rights and duties of other states. End of quote. The term due regard appears 22 times in the Convention. Although one should be careful to transpose the findings in relation to a specific term, in a specific article, in a specific case, I would submit that the tribunal's clarification also provides guidance in other instances where the Convention refers to the term due regard. Another example is provided by South China Sea, where the arbitral tribunal handed down a detailed interpretation of Article 121, paragraph 3 of the Convention, which, as was already mentioned, provides that rocks without which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. Again, a compromised formula open to diametrically opposed interpretations. Although the tribunal's interpretation on Article 121, paragraph 3 on many points is reasonable, it may be noted that much state practice seemingly diverges from that interpretation. That obviously carries a risk if the gap between the case law and state practice will persist. As South China Sea, but also Chagos, and the two cases under the Convention between Russia and Ukraine indicate, compulsory dispute settlement under the Convention has dealt with cases with a high political profile. This highlights the significance of less powerful states attached to compulsory dispute settlement under the Convention. In particular, China's stance in South China Sea raises question about the implications for the future of compulsory dispute settlement under the Convention. I would submit that courts and tribunals, to ensure the stability of the Convention, should not shy away from dealing with such high-profile cases. At the same time, continued support of the states parties to the Convention is essential to ensuring the continued contribution of compulsory dispute settlement to its long-term viability. That brings me to some brief final remarks. Compulsory dispute settlement, in my view, has contributed to the clarification of the law and therewith the stabilization of expectations and the predictability of the law, but only to the extent specific issues are submitted to courts and tribunals. And in addition, not unimportantly, compulsory dispute settlement has contributed to settling specific disputes. As regards the clarification of the law, it's of interest to further reflect on the question to what extent the judiciary has contributed to addressing the fundamental questions facing ocean governance. In general, it would seem that this role has been limited, except perhaps for the advisory opinions of the Unclos. And there may be further scope for using advisory opinions in this respect. This limited impact may be due to the fact that these kinds of questions generally have not been included in the questions that have been submitted to courts and tribunals. And perhaps these matters should in any case be left to the international community. And courts and tribunals shouldn't be involved in that debate. However, the experience of human rights courts and the European Court of Justice do show that the judiciary can have a fundamental impact on the development and operation of a legal system at the international level. But perhaps these bodies operate in too different a setting to allow for a meaningful comparison. There is one notable example to the above situation, I would submit. Courts and tribunals have clarified the extent of judicial jurisdiction under the Convention. And this is obviously critical to the proper function of compulsory dispute settlement under the Convention. Put somewhat bluntly, it is a choice between doing too little by refraining from recourse to rules beyond the Convention to a large extent, or being viewed as doing too much by seemingly settling aspects of a dispute that are not concerned with the interpretation or application of the Convention. The Convention only explicitly refers to this matter in its Article 293, paragraph 1, which provides, and I quote, "A court or tribunal having jurisdiction in this section shall apply this Convention and other rules of international law not incompatible with this Convention." End of quote. However, at the same time, the Convention refers explicitly or implicitly to other rules of law. And taking into account these other rules of law may be required to settle the dispute under the Convention that has been submitted to a court or tribunal. At the same time, there has to be a limit to deciding the issues that are beyond the remit of the Convention. Part 15 was not intended as a means for settling all disputes under international law. Striking a proper balance between these two considerations will remain one of the main challenges to Part 15 and compulsory dispute settlement in particular in the future. And as one may note, there is a link here with the high political profile cases to which I referred earlier. That concludes my observations. I thank you very much for your attention and look forward to the discussion. Thank you.
Thank you so much, Professor Elferink. Because we only have about 8 minutes before we finish, we'll open the floor for questions from the audience, perhaps 1 or 2 questions. I see Clive. Yes, please, go ahead. Professor Clive Schofield.
Thank you very much indeed. I do hope that Judge Wolfram, Professor Wolfram, is still with us and online, because my question essentially goes to Judge Wolfram, but also hopefully for our other judicial colleagues who are with us, and hopefully I won't start a fight between judges with that question. Judge Wolfram, I was very much struck by your comment that decisions of international courts and tribunals should be binding upon subsequent following courts. I was rather impressed by your ability to, as it were, throw tradition out of the window with this thought. It does strike me, when looking at the jurisprudence of international boundary delimitation particularly, that courts appear to be quite respectful of earlier decisions, frequently quoting or referring to those earlier decisions for the support of their views. Judge Treves highlighted how the International Court of Justice, in its latest decision in Somalia-Kenya case, actually referred to the Bay of Bengal ITLOS decision, as well as the Annex 7 arbitral decision between Bangladesh and India within the ICJ's ruling. Is this not enough, Professor Wolfram? Or put another way, if I can channel Judge Treves for a moment, is this collective interpretational endeavor not harmonious enough? Do we need more? Thank you.
Thank you very much. Please, Professor Judge Wolfram.
Yes, thank you very much for this question. I will apologize for I have to leave in 5 minutes before I have to be tested, since I'm leaving for Chile tomorrow. To your question, I am not complaining about subsequent courts. They have so far been quite respectful in respect of the ruling of previous courts. You can see that in relationship of the ICJ in the Black Sea case, which has been followed by arbitration and by Unclos quite clearly. I'm not so much concerned with the question of delimitation. I'm more concerned with other pronouncements of the courts in respect of fisheries, etc. And here I would recommend that the following courts, they put it again in one sentence, should not only be respectful in respect of previous judgments or advisory opinions, which I might add, but should follow, and now comes the important sentence, unless they have excellent reason to deviate, and they have to explain in detail why they change. Let's take refer to the arbitration in the South China Sea. There is a long debate about what is an island and what is a rock. Subsequent courts should in detail may say otherwise if they have very good reasons, not only factual reasons, also reasons based on the interpretation of the law. You may consider this only a small step. It is more. It is leading into that courts establish a jurisprudence, and this jurisprudence is de facto law. And this is dogmatically quite progressive, let me put it this way. If you prefer, you can also say it's revolutionary. Thank you.
Thank you very much. Another question from the floor? Yes, please.
Yeah, thank you, Patricia. And thank you all for your wonderful presentation. But my question is to Judge Koroma. I recently discovered and I was reading this amazing book written by British environmental writer Paul Harrison in 1979 about, it's called Inside the Third World, and Identity to the Poverty. So I thought it's really fascinating for me to capture what he described, the struggles and difficulties for developing countries to not just sort out its domestic issues, but also to successfully navigate in this current international legal system, or the so-called rules-based international order, to develop their economy. So I can see that there is a clear kind of north-south division in the law of the sea, as reflected upon the debate on the common heritage of mankind 40 years ago and now in the BBNJ. But my question to you, Judge Koroma, is I'm really seeking your opinion and wondering, when it comes to the dispute settlement mechanism per se that we are discussing in this panel, that I see that all the presenters mentioned these cases, that actually the dispute settlement mechanism provided a kind of a mechanism to help developing countries to solve their issues, but also the issues between developing countries and developed countries like Mauritius and the UK. So is there a north-south gap or division in the dispute settlement mechanism per se in the law of the sea? Or what do you see this question there? Thank you.
Thank you very much, Judge Koroma.
Thank you very much for your question. I don't think there is a dispute regarding the acceptance of judgments from tribunals. You cited a number of, first of all, in the case, it says the latest judgment between Somalia and Kenya, of course, governments are bound to express their disappointment, but I'm not speaking officially, but I think that's a reasonable judgment. And so by and large, I think it will be implemented. Or Cameroon, Nigeria too, as you would recall, the governments undertook to implement the judgment, and they are in fact largely implemented that judgment. And before that, okay, it was not a maritime dispute. Burkina Faso, Mali, too, was respected. Our interest in the Law of the Sea Convention at the time, in terms of the common heritage, which Judge Wolfram referred to earlier on, was to ensure that the resources of the sea or maritime space would not only be divided up among the developed countries, that there was a new order which had emerged in which the developing countries should also participate. And I think I wouldn't say, to a large extent, we succeeded in ensuring that the common heritage of mankind principle was enunciated and adopted into the convention. And listening to one of the participants this morning, I don't imagine that she had participated in that conference, but I came to the conclusion that she's of the view that that was and is still an eternal verity. So, but where judgments or acceptance are concerned, no, I don't think there are differences among developing countries. Thank you.
Thank you so much. Unfortunately, I think it's time for us to wrap up. This has been an excellent discussion. I want to thank warmly all the 5 panelists, the ones here, and also the 2 panelists that were online. This setup, I think it's as good as we can get for a hybrid setup, and I'm very glad that we could do it even if we're not all in person. I'm not sure if there are any housekeeping. I see Pia coming, so I'm sure there are. But once again, join me in a round of applause to panel 3. Thank you very much.